Well, on behalf of the Philosophy Department at Fort Hays State University, I'd like to welcome you all here. I'm Douglas Strabkin. I'm one of the teachers at the school. This is Chris Rohr.
A little bigger than you are?
Well, everyone's bigger than me, but I can say he's a once and future graduate of Fort Hays State University, assuming you pass your thesis.
Yeah, we hope.
We hope. He is the first of 2 senior theses that are going to be presented today. There are going to be 2 more tomorrow, and then 2 more next Tuesday. And if you don't have a copy of the paper and you want one, are there still some in the back? There should just be copies for today's paper and the 2 papers from today. I don't think we have copies for you. Also, we're going to be breaking at 4:55, no later, for a very brief refreshment break. And if you need to leave, that would be a good time to do. There are going to be cookies, I think, and drink. And then we'll be starting right up here at 5 o'clock for the next round, or just a couple minutes later. So what else can I say? What can you expect? Well, he's written a thesis, but he's not going to read the whole thing to you because they don't have time. He'll be talking for, what, 15, 20 minutes or so? If you're really clueless about what he's saying, you can raise your hand and say, I don't understand that point. Or could you explain that? And you're willing to do this. Although, if you have objections and things, and surely you will. It's hard to do one of these things without objections popping to mind. Hold them. Because we're going to have 2 or 3 times the amount of time he's going to be presenting here for discussion. All right? So jot your questions down. That's what this is largely about. It's for him to present his ideas and then to field questions. Okay, so Chris Rohr.
Well, like Doug, I'd like to thank you all for coming. And the title of my thesis is, Should Tainted Evidence Be Admissible as Evidence? And it's a defense of the exclusionary rule. And we're going to start off with a few definitions. As I was going through this, I thought I should probably define a few terms. And probable cause is the standard of proof that officers need when they conduct a search. So to better explain what probable cause is, the highest burden of proof that the court systems have is beyond a reasonable doubt, and that's used for criminal court cases. And then the one under that is preponderance of the evidence, and that basically means more likely than not this incident occurred, and that's used in like suppression hearings and civil court trials. And then probable cause falls under preponderance of the evidence, and then under that is reasonable suspicion. So that gives you an idea what probable cause is. And an unreasonable search is basically a search that lacks probable cause or any other factor that makes it legal. As I get into my topic, there is a series of limitations to the rule, and that'll help better explain that. And then a prosecutor's case in chief is basically when the prosecutor presents evidence in there. So I shall begin. And the Fourth Amendment of the United States guarantees us the right against unreasonable search and seizures. The Fifth Amendment guarantees us the right against self-incrimination, and the Sixth Amendment guarantees us the right to counsel. And the one thing that all these 3 amendments have in common is originally there was no remedy in place to protect Americans from them. And that's essentially the topic of my thesis. And the case of Irvine versus California, I think, illustrates the point on how important these rights are. And in Irvine, the police were investigating him for violating gambling laws in California. And to do so, they hired a locksmith to make a key to his house to gain entry without a warrant, and they did this 3 times. The first time, they installed microphones in his hallway so they could track evidence, so they know where he was at. And then the second and third time they came in, they copied like papers to use against him. And it turned out that's essentially what happened. The state pressed charges. He ended up getting convicted. The appellate court held it, and the Supreme Court held that decision, even though the Supreme Court had stern words against the police officer's actions. And the reason for that is because there was no remedy in place to protect the Fourth Amendment in this case. And one of the things I hope you get out of this is that the Bill of Rights' purpose was to protect the Americans from the government. And the Bill of Rights just outlines our rights. And to a certain degree, it's up to us as individuals, as Americans, to assert those rights. And if we don't, we can lose them. So, 1953. It fell in between, I guess I'll explain that. In 1914, the exclusionary rule applied to federal courts. And then in 1949, they applied the Fourth Amendment to the states, but not the exclusionary rule. And it wasn't until 1961 when the exclusionary rule applied to the states. So there was a gap in between there. And then the remedy the Supreme Court came up with was what's called the exclusionary rule. And it's basically a judicially created remedy to remedy the rights in the Fourth, Fifth, and Sixth Amendments. And the way the exclusionary rule works is if there's been a constitutional violation of one of these rights, then that evidence cannot be used against you. That was how it was originally set out. And then as the exclusionary rule evolved over time, there's been a series of limitations. They're on the bottom of page 7 for those who have papers. And during the question and answer session, I can get more in depth into them and explain them further. So. And then the moral theory that I use to evaluate the exclusionary rule is what's called consequentialism. And essentially, a consequentialist is going to focus on the end result of that action to determine if it's right or wrong. And then also, the second principle is the more positive consequences that action produces, the better that act is. And some of the common arguments, or the major argument for the exclusionary rule is that it deters police misconduct. And I think to take a second to talk about deterrence would be noteworthy here. Essentially, the exclusionary rule is founded on the assumption that it would deter crime. And deterrence is a theory that uses punishment in order to nudge people in the right way. And so the theory was if the cops knew that the evidence could be excluded, that in itself should be enough to stop them. So you can deter people as a threat to punishment, or you can even deter people through education. You can look at it through that way, that we put these laws in place to better educate our police officers, and in the end result would be less violations to the rule. And many advocates of the exclusionary rule claim that it does deter police misconduct, and they acknowledge that there have been studies out there, but they discredit those and they base it off their experience. That after Mapp v. Ohio in 1961, when the rule applied to the states, they saw a large increase in the amount of search warrants that were out. Thus, essentially, and police officers were getting trained more. There was actually a New York City police commissioner that was quoted saying that the Mapp v. Ohio decision sent tidal waves and earthquakes through the law enforcement community because they had to retrain all of their people. And a lot of people question why, because the Fourth Amendment actually applied to the states in 1949. So why 12 years later are we having to retrain all these people? And then another set of arguments that I used in defense of the exclusionary rule is that the courts honor and underscore the value of these rights by paying such a high price to them, essentially throwing out what in some cases very credible evidence against the defendant, and they just claim that if they admit the evidence, as the second point notes, that the integrity of the judicial system wouldn't be as high as it should be.
Can I ask a clarification question, please? Now, the Fourth Amendment, that's the one about unreasonable searches and seizures?
Right.
Right? Now, when you say that it applies to the states, does that mean state police doing unreasonable searches and seizures as opposed to federal police?
It's
What's
yeah,
the idea?
yeah, individual states. Yeah, so it would be state. You would have we have a dual federalism system. Mm-hmm. We have the federal courts and the state courts. So initially, when the exclusionary rule came out, it only applied to federal courts.
So it has not to do with the police. Doesn't have to do with the police, but what court the thing is being tried.
Right, but the police would still be under those laws, yeah. If that state had the exclusionary rule. And there were some states that had the exclusionary rule prior to the Mapp decision. I think there was 23. Okay. But also the one thing that I saw that it seemed to be a common problem in the exclusionary rule was a lot of the criticism of it seemed to be misguided, that they're targeting it at the exclusionary rule when it should actually be targeted at the amendment itself, because it's the amendments that guarantee people these certain rights, not essentially the exclusionary rule. And advocates of the exclusionary rule also, they acknowledge that there are alternatives to the rule, but they think that the exclusionary rule is the best possible remedy for this. And that's essentially what I concluded in the end of my paper, that compared to all the other theories involved, the exclusionary rule seemed to produce more good because it helped professionalize modern day policing. It's a deterrent for police to invade into people's lives. And what I want to conclude my presentation on is basically the rights that are guaranteed in the United States Constitution set us apart from the rest of the world. And it is us as Americans who have the responsibility to make sure that those rights are protected. And if we don't, then nobody else is going to. So that may have been, but we can turn it over to questions or clarifications.
Well, there's one I've been wanting to ask you. Okay. Now, there's this guy in your paper called Wilkie.
Yeah.
And Wilkie provides, according to you, 3 alternatives to this exclusionary rule, that he supposes will get will protect the Fourth Amendment and all, or apply the Fourth Amendment, but will still allow, when you find that there's this rotten criminal out there, will still allow that evidence into court and put these guys behind bars, right? And of those 3 alternatives, one stood out in my mind sounds good to me, and it's the one, I'll just quote from your paper, right? But basically, putting the cops on trial. It's the third of the alternatives. So let's say people, I don't know, they don't get a proper warrant, and they go in there and they find, I don't know, this horrible stash of this, that, or the other thing, and a conspiracy plot for who knows what, and a dead body. All right, it's all there. Okay, so they don't have a warrant. What happens? Well, this evidence gets dumped in the courts. These people stand trial, get locked up. But then, new trial. The cops go to get tried, and they say, "What were you doing this?" And this comes up, before the court, and they go to jail, or something, and depending upon what, how bad it was and what their basis was. Now, this is what you said in the paper. These weren't your words. This is quoting somebody else, a guy named Del Carmen, who said, if the violation were slight, well, then the judge or jury would not look with favor on what may be considered an unnecessary extension of the original trial. If the criminal trial ended in a conviction, the chances of the officer being punished for what he did is remote. Now, you didn't comment on that. I thought maybe you could comment on this now, because it's not obvious to me that this is a bad idea. This way, just the point being, the good thing about this is that the evidence doesn't get thrown out. I mean, truth is out. But on both sides, the truth about the cops and the truth about the other criminals. So as you see it, what's dumb about this, or why is this better, not as good as the exclusionary?
Well, I think there's 2 more problems with essentially that remedy, and one would be the delay time between the arrest and the trial, and also the way our court system is set up to where we have the main trial, then we have appeals, and we can appeal up to the Supreme Court. So let's say we had a case where the trial judge finds that the police acted out of their duty, and they try to put him on trial after the main trial, and then there's an appeals process, and the appellate court judge says, well, he wasn't acting out of his duty, and then so it gets either sent up to the Supreme Court or back down to the trial court. And let's say the trial court affirms it. I mean, we're going to be putting police officers on trial in some cases years after I think this actually occurred. And the other problem I think is judges and juries in the United States are reluctant to put police officers in jail. And that runs into the same problem with the tort remedy. That was one of the other alternatives. Yes, sir?
Yes, it can also be a question of what the officer's intent was. I mean, you can, in search and seizure, sometimes you have a clear-cut case. They go barging without a search warrant. Well, that's a clear-cut case of an illegal search. But you also have borderline searches, borderline cases sometimes too. And I think it would be a borderline, but it would a lot depend in the trial of an officer what his intent was. Did he do it, willfully go in for no reason at all? Or was there a borderline situation whether or not a search warrant was needed? In search and seizure law, I think you do have a lot of borderline situations.
Yeah, there's a lot of gray, and there's actually an exception to the exclusionary rule called the good faith exception, to where, let's say, a police officer, the case that came out was United States versus Leon in 1984, And that case dealt with a police officer who they actually filled out the search warrant, to get it, and they had the judge sign it. However, they didn't fill out the wrong piece of paper, or there was some information that was wrong on it. And the defense tried to file a motion to suppress later in that case, and the judge ruled that, the Supreme Court actually ruled that the police officers in that case were acting under good faith, so that evidence could stay in. So if the prosecutor can prove that the officers were acting in good faith, that evidence could come in. And there's also a series of other limitations as well, where, like another one, like the independent source doctrine, basically if initially the police officers find evidence illegally, let's say they barge into a house and copy a bunch of papers, and they didn't have a search warrant for it, and then they go back and get a search warrant and copy those same papers, that evidence can get admitted as well. So there is a lot of gray area in the exclusionary rule, like when it applies and when it doesn't apply.
Can I just follow this up with one thing? But to hear you say this, look, there are a lot of exceptions, and it might turn out that the cop's situation is in one of those exceptions. But if that's the truth, that's the truth. Is that a bad thing? Isn't that what a trial is all about? They would stand trial, and then it would turn out, oh, this fell under one of those exceptions. So it was actually an okay thing that they did.
Yeah, but I think you're forgetting that we have to follow the guidelines of the Constitution as well. Truth is very important, but I think the guidelines of the Constitution are going to supersede even the truth-seeking process in the trial. That's how it appears to me. So,
This whole thing is steeped in a notion of freedom, that we don't do what is advocated there because in the process we're still violating somebody's freedom without due cause. And so I'm wondering how something so deeply against freedom in the most broad, even well-based sense, like the silver platter doctrine, gets in, where a state can violate the Constitution and present all of this to the federal government for federal charges, and the federal government can ignore the content legally. I'm wondering where that fits into this whole.
yeah, I agree. I really don't understand the actual rationale under the silver platter doctrine, where if the state police violate it, they can hand it over to the federal government. Maybe their rationale is that the federal government wasn't a party to the search, and so they should still have access for their cases. There's also the inevitable discovery doctrine, which came out of Nix v. Williams, where a little girl got murdered, a little 10-year-old girl, and the suspect dropped her body off on the side of the road. And he asserted his Sixth Amendment right when the cops got there, so the interrogation should have stopped, but they continued to press him. And he ended up telling them where the body was when they found it. But it just happened to be the search team was within like 200 yards from the body. So in a case like that, the cops argued that that would have been found anyways. Yeah, but some of these exceptions to the rule, and a lot of advocates agree that they go too far, and that essentially we're limiting the guarantees that were in the Constitution instead of supporting it, especially with all the limitations that there are on it.
How does the exclusionary rule apply to electronic data that may originate in a user's home but then traverses public lines or something?
Yeah, that's a good question, and honestly, I honestly don't know. So.
It seems like in the beginning, when the exclusionary rule was proposed, it was sort of an absolute prohibition of legally obtained evidence. It seems like the court, as you said, with the exclusions or exceptions, seems to be providing more of a balancing test. We want to balance the value of the evidence versus the harm to society and so forth. Do you think they should use a balancing test, or do you think it should be more of the absolutist approach where it doesn't matter how much society is harmed, illegally obtained evidence should not? Do you want to get rid of these exceptions?
Well, advocates of the rule would want to get rid of the exceptions, but like me personally, I think some of the exceptions actually make sense, like the good faith exception. If people are acting in good faith, if police officers are acting in good faith, then we shouldn't penalize them for that. I think some of the cases, like there was a recent case where there was a court error, where the court clerk erred, and they ended up searching the wrong guy, and they found evidence on him and prosecuted him for that. And in that case, they upheld it, even though it was an error on the court, because they didn't think it would deter police misconduct. I personally think that, where should there be a balancing test? I think there should be. I mean, to a certain extent. I mean, especially in like heinous crimes like murder and stuff like that. I don't think that we should be letting. I think we should balance the. Yeah.
So if it's murder, you're okay with illegal searches and seizures?
Well, I think that, like me.
Yeah.
Well, I think.
This position.
Right. Well, I think there are some crimes when people are obviously guilty. I think that we shouldn't be getting rid of them in that sense. But I mean, I think that.
So the severity of the crime should determine whether the evidence is excluded? So if it's just tax fraud, maybe we should exclude the evidence, but if it's murder, we should not?
No, I mean some countries balance their system like that, like Germany does.
Should we?
But I think that's what we're doing now. I think that's what the court's doing now. If we look at
Do you think
the
that's right
history,
that they're doing
well, to a certain degree, but
that? So the constitutional laws or constitutional rights should be thrown out when you've done something bad enough.
well, I think if you're obviously guilty and that the
That's what the
and that
trial determines,
right, and that it's prosecutor's job. I mean, even like in a motion to suppress hearing, I think if the prosecutor can prove that that evidence should be admitted, then it should be admitted.
But you want to base that on how bad the crime was.
Yeah, that's what I said.
I mean, I think you're getting wrapped up here a little bit. What I think you're proposing is that it's a matter of, one, how bad the crime is, and two, how egregious the violation is. That at some level, you know, it should be harder to preclude evidence from a murder. But if the police just run roughshod over everybody's rights in the way, that still's enough. Is that what I'm reading?
Yeah.
Whereas in a minor tax fraud case where a law enforcement officer barely bends a rule, that it should just be, because it's something that's so minor that a major offense, of course, gets it kicked.
Well, I think if there's
But
a
a minor offense that would pull par as well.
I think if there's a flagrant disregard, I mean, on the police officer's behalf, that in cases like that we shouldn't. But, I mean, in cases where we can prove that they're acting in good faith, I think it should.
I'm just curious about the overall argument, because you say it's a consequentialist kind of argument. Is this then hostage to the empirical data? I mean, if I can prove to you, because I do some massive sociological study, turns out, no, the exclusionary rule doesn't affect officer behavior at all.
Well, there have been studies on the exclusionary rule. And,
Right, I mean,
Right,
and
mhm.
so we'd have to wrangle about the data, but is this then sort of hostage to that data? If somehow I could persuade you that, no, there's
Well,
no
I mean,
evidence that it doesn't.
yeah, how advocates of the exclusionary rule claim that, I mean, how are you going to do a study that proves that it deters police misconduct without getting inside of them? I mean, at that point in time.
Well, I mean, but it's a principal question, because you could look at, say, I mean, there's some stuff, do we or do we not see decreased rates of, egregious violations? So just a matter of principle, is if I'm understanding this correctly, is your argument then dependent on that kind of data? Because one could just simply take a non-consequential view. It doesn't matter whether it affects anybody's behavior or not, we just ain't doing this. We're excluding tainted evidence, because it's just wrong.
Right.
A consequentialist is going to say, well, it's wrong because it tends to have positive results if we do exclude this evidence. I mean, if I'm reading this right, that's what the case is based on, is the at least alleged positive results.
Right, that's what, yeah, advocates of the exclusionary rule, they,
Such as yourself.
do what?
Such as yourself.
Right, yeah, I mean, there have been statistical studies done, and there have been extensive studies done, and actually those studies show, the most famous studies show that after Map v. Ohio, the crime rate did decrease, and critics of the rule don't attribute that to the exclusionary rule. They saw the trend happen way before, but I mean, so the statistical evidence there, I mean, some of it works for the exclusionary rule, some of it works against the exclusionary rule. But what advocates, I mean, they base this off their experience. Like a lot of the people I used in the paper were Supreme Court justices, and Stephen Sachs was an assistant U.S. attorney, and he saw what he saw from his people and the people he contacted with was that this does deter police misconduct. It actually forces them to follow procedure more.
So it is then based, the defense is based on this, and it's sort of dependent on this evidence.
Right.
I guess that was really my
Yeah,
question.
right. Hopefully that answered it.
All right.
Yes, sir.
Okay, in 1949, they said the Fourth Amendment applies to the states, but they refused to make the exclusionary rule applicable to the states. Then 12 years later, in 1961, they made the exclusionary rule applicable to the states. Well, in that 12-year period, what types of sanctions were taken against officers that, when the evidence was still admissible in court, or what kind of sanctions were taken against officers who conducted illegal searches? Are there any studies on that?
And the case that I pointed to, Irvine v. California, came in 1953 between those two times. And in that case, the court upheld the conviction, even though they did break into his house.
Not only upheld the conviction, but were any sanctions taken against the officers, though, despite their conduct?
Yeah.
I mean, was there a civil suit or any criminal prosecution of those officers?
Yeah, that I'm not sure.
I'm going to change the subject slightly, okay? You claim in your paper that the Fourth Amendment, the basis, one of the main bases for this rule of the U.S. Constitution, is the most sacred right that we as Americans possess. All right. Setting aside the question about whether or not sacredness comes in degrees, could you say anything about why you think this is so? What is it about the sacredness of the Fourth Amendment? Could you speak to this a little?
Yeah, I think what the Fourth Amendment protects are particular privacy rights, like the right to be in our houses without government intrusion. And I think that, I mean, I quoted that from a source, and he agreed. But I think the value of privacy and liberty, I think that the privacy rights that the Fourth Amendment encompasses are rights that make us unique, like as a country, that no other country has, I mean, the exact same protections that we have. And I think that that's why I personally think that it's a very sacred right, and it's a right that shouldn't be taken away from us. We
have red, white, and blue flags and things like this. There's a lot of things that are unique about our country. This one, though, is sacred. Right. This is the language of religion. Right. This is special. Mm-hmm. I mean, I realize this is typical of it. There's a lot. We have the biggest military in the world too. But, right. Is that sacred too? I don't know. There's a lot of weird things that's true about us. All right. Let me give you a thought experiment. Just a thought experiment for a second. Privacy. Take privacy. Okay. A lot of people are on Facebook these days, I understand. I'm not yet. I'm holding out. Suppose everybody were on Facebook someday. And what's more, you know how people have their status constantly being presented as Facebook? Well, you don't have to do this. This is all going to be automatically done. All right. There's going to be no room bigger than a garbage can on Earth where there's not going to be some webcam. You watch the president go to the bathroom, everywhere. There's no privacy, all right? The whole world is a glass building, okay? As you see this, would this be rotten? No privacy? I mean, is privacy a precious thing, a sacred thing? Is this something that's defensible, and if so, why? What's the theory here? I'm curious.
Yeah, I think privacy is very important. I think if we lived in a world where we were watched 24/7, then I mean we would have no time to let off our steam, or we'd have no time, I mean, for ourselves to be ourselves.
Well, we just do it for everybody. I mean,
and I mean, like the Fourth Amendment came from, I mean, where the British government was intruding into the Americans' lives, like the writs of assistance, where they would go in, writs of assistance were like a type of a search warrant that the British government used to control how their people did business. They wanted them to specifically do business with them. And so, I mean, that's essentially what was one of the points that started the revolution. So I think that those privacy rights, I mean...
But they were doing that to us, but we weren't doing that in terms of the king. In this bizarre scenario, there would just be no privacy. Let's just abolish it. Get rid of it already. Maybe this is overrated. Maybe it's not sacred at all. Maybe you have a hang-up, this privacy thing. I mean, it's one thing when you fear the king or the governor or whatever, but if we just did away with it.
Well, I mean, you personally could do away with your individual rights of privacy. Well, I mean, but I'm not going to give up with mine.
I know you. I can see that you're very touchy about this matter, and I'm wondering if there's something defensible about it. I mean, it's something that seems that we take for granted in this country, and you maybe don't. Maybe you're raising it to the level of sanctity,
right?
Sacredness. Is this a little overrated? I mean, look, I wonder if this is defensible.
The right to privacy, is the right to
Well,
privacy
yeah, I mean,
defensible?
that privacy is actually a value worth caring about,
Is it necessary for liberty and civil law?
for anything.
Well, I think it's necessary for freedom. I think if we weren't, I mean, if we live in a country that we're free and then we have people intruding into our lives, I mean, are we really
You can
living
intrude
free?
back at them, I mean, you can look.
Yeah, but I mean, that, we would still be intruding into their lives, and I mean, to me, I mean, I think it's an essential ingredient of freedom to be able to do the things that we want to do, especially in the sanctity of our home, or even in or places where we can show we have a particular right to privacy.
Do you think that right is defensible in the same kind of way you've defended the exclusionary rule? In other words, by consequentialist means, by the good that it produces in terms of individual happiness or collective happiness? Or is it, I mean, the language of sacredness to me suggests that maybe it's not consequentialist. And I know you've looked at some other ways of defending the exclusionary rule that you know, maybe didn't make your paper, but so I'm just sort of interested in your take on what the right to privacy is grounded on. Do you think it's consequences or something else?
Well, I think that it does produce, I mean, it does for a society produce good consequences in the end, but
Like what?
like people are free to let their steam off and they're not hostile all the time. And I mean, and I think what we've seen in other countries when their governments do intrude into their lives is they start revolting against their government and stuff like that.
May I take issue with that particular consequential justification? It seems to me that privacy is not good in and of itself. That any right to privacy the 4th, 5th, or 6th Amendment may provide us can only be good insofar as it allows the other amendments to take effect. What right to religion or press or any of the other, or assembly, do I have if the government or another person, another agent, can track what I'm doing and take actions to prevent me from exercising that right? I don't see necessarily this as being good for society in so much as those other rights are good for society, and therefore privacy is necessary. Does that work better, or is it something?
Well, I mean, yeah, I think there are, I mean, the whole Bill of Rights, I think, are rights that we all should value. And I mean, how we rank them, I think, is up to the individual. I mean, if you're a very religious person and you're very, you want to speak your mind, I mean, the First Amendment may gear to you, but I think, for me in particular, I think the right to privacy, I mean, is up there at the top.
So I guess what I'm asking you is, what is it about privacy that makes it valuable for its sake and not for its consequences?
Yeah, that's a good question.
Mr. Rohr.
Yes,
can you
Mr.
read
Gable.
my mind?
Why am I here?
Perhaps that's what I'm thinking, but do you know that for certain?
Do I know anything for certain, I think?
Do you know what my thoughts are for certain? There's a certain security knowing that you cannot read my mind, nor that I can read yours, isn't that correct?
Right.
So isn't that sort of a very insular example of privacy? Is there a good in not being able to read my mind, or my being able to read your mind?
Well, I mean, we could end up hurting each other in the end, I mean, to a certain degree.
So let's go ahead and extend it out a bit more as far as privacy is concerned. Let's expand it out into the garbage can size group that Professor Grabkin has posited before. Is there then ability to, for you, at least in that smaller room, to collect your thoughts and to be able to reason through those yourself?
If I was
Invasion from anyone else, just like within your mind.
If I was in the room by myself, like, would I be able to gather my thoughts
Right.
in a small room?
No, in a
think-
small group. Oh, I'm sorry. Did you say small group or small?
Small room, small room. Like a trash can. I guess there's a garbage size can.
Yeah, that'd be a pretty big garbage can.
Yeah.
Could you at least be with yourself, with your thoughts in that particular situation?
Could be.
Is there a value to at least you excluding others from that small realm, however small it may be, so you can be with your thoughts?
Yeah, I think that we should be able to exclude people from our thoughts.
How about a larger room? Say, like the size of this room. If you could be in there by yourself with your thoughts, and perhaps abstractions of those thoughts, such as these pictures on the wall, such as the paper that you present.
Is there a value to that?
To being able to be in privacy, I think in some cases, yes.
And how about if someone intrudes upon that?
Yeah.
Would you like to prevent that from happening?
Yes.
So isn't that the reason why privacy is somewhat sacred? To be able to be alone with your own thoughts and the abstractions of your thoughts, be it in your own mind or in a room that you've constructed or something.
Yeah, I'd agree with that.
But who wants to do such a thing? The only I was watching The Sopranos with my teenage son last semester. This is about this mob family, and this keeps on coming up because the feds keep on wanting to, like, this is organized crime we're talking about, putting like listening devices. But there are a couple places where this is forbidden, in doctors' offices, for instance. And so these mob bosses will be meeting in these doctors' offices where the doctor, they buy them off and they send them out of the room, and then they talk about who they're going to be hitting and this kind of thing. Evil. I mean, what privacy allows is evil. If we just shed our clothes, broke down these walls, and we're just open with one another, it would be a little weird, I admit, but it would be harder for these criminals to do their criminal things. I mean, in heaven, do you suppose there are little locked-off rooms where people kind of can hide from God in case he's watching or something? Surely not, the argument would go. And so, by the way, I'm sympathetic with what you're saying, but it strikes me that this needs a little defense. I mean, what privacy is good for is crime.
Is he?
Well, I mean, and things that you're ashamed of in general, for one reason or another. Why not just let it all hang out?
Because I have the Constitution that
open
grants it
and
that I don't
honest?
have to.
And have a harmonious society like the Chinese do. Or something. I don't know, just a suggestion. Yeah.
Yeah, but I think this abstract thought experiment is forgetting is that we have the Constitution and the Fourth Amendment that's granting these rights to us. So, I mean, if we want to throw it away, we'd have to get rid of the Fourth Amendment to throw it away.
Sure, we can do that.
I mean, I think that we should preserve the rights that we have. We shouldn't just let them slip away. There's a reason that they're there in the first place.
And there's a reason we're philosophers and not lawyers, right? Because we're not enslaved to the U.S. Constitution. We can rip it up just like that in our minds and replace it with something better.
3 years from now, I don't know if I'll be able to.
Yeah, I know where you're going.
Yeah, but the point is that making the argument that the Constitution is a good document only insofar as it advocates for rights that are actually useful. And so if the Fourth Amendment is completely bogus and unnecessary, or if by some natural catastrophe we lose all the military barracks in the country all at the same time somehow, and we now have to quarter soldiers somehow, perhaps we should either temporarily or permanently excise amendments from the Constitution or the whole Constitution itself to provide for a greater, better need. And so if you're going to defend the Fourth, Fifth, and Sixth Amendment, don't you have to in itself defend privacy?
Yeah, I mean, because privacy is a core root of the Fourth Amendment.
And so we're back to the same question. What is it about privacy?
But it's ultimately not defending the Fourth Amendment necessarily, it's defending the exclusionary. You've got to keep track of what's actually happening.
Yeah, Doctor.
Yeah, so near the end of your paper, you have a quote from Justice Brand.
Yeah, I think so.
It starts out with, quote, in a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously. Wondering, maybe if you say a little bit about that argument. If I'm understanding this quote, Brandeis is making an argument, taken in support of at least could be used in support of the exclusionary rule, that's such that whether the Fourth Amendment is good law or not is irrelevant.
Right. I mean, I think the point he's trying to make is the government should hold themselves to a higher standard, and that they should follow the law. And especially if they expect their citizens to follow the law, and they should, if we're talking about the same quote, and they should essentially be the teacher to the citizens. And if the government's breaking the law, and then that just breeds more lawlessness in society. So the government should hold themselves to a higher standard, I think, for the overall good.
Actually, I'm curious about this. Is this, do you take this to be consequentialist? I mean, and that, is he literally saying that there would be more crime, that it would breed more crime, or is it something other than consequentialist? That Brad uses here?
I think that, I mean, he's saying if the government, I mean, were to break the law, I think that's a sign to their citizens that essentially it would be okay to break the law. I mean, if they aren't following the law, then essentially why should we?
Okay, so you do take it as
Well, there would at least be a statement that it would be okay, whether or not it actually, I mean, that's how I read it. So I read it as non-consequentialist.
I want to pick up on that point. I was thinking about Mexico. We were talking in our ethics class today about the problem with police corruption in Mexico. And it seemed to me that this point about not wanting the cops to break their own rules might apply. I wonder if you had come across anything in that in your reading on whether that might be a consequentialist argument that look, once the cops start going bad, you're going to have a really hard time. And you look at what's going on in Mexico. They basically had to bring in, turn into a police or a military state because they can't trust the police.
Mm-hmm.
What do you think about that?
Yeah, I mean, yeah, I would agree. I think if the government was breaking the laws, it would be hard to contain that. But more, I guess more specifically, what were you, can you restate the question?
Well, I guess I was wondering whether you had come across anything like that, because it seems to be, in a couple of the quotes in your paper, sort of suggested very broadly that bad cops are really bad things to avoid, right?
Right, yeah.
Dirty cops. But I wondered if you had come across that and whether you think it really would be a good consequentialist objection.
Oh, yeah, I mean, there was a case I ran into about Katherine Johnson that the government got the no-knock warrant and they went in to her house and they ended up killing her. I mean, is it something the same of that lines?
Well, no, I guess I was thinking much more broadly in the sense that once a police force is corrupt, it's almost impossible to have that police force right itself.
Right.
And so part of the sacredness of the rules might have to do with just the fact that when the people who are enforcing the laws aren't enforcing the laws, you're up the creek.
Yeah, I would agree with that. And
If you hadn't come across anything.
I think there was like times like with like the LAPD, they had problems with crime there. I mean, something to that extent. But as for in particular for this reading, no.
Okay.
Well, but isn't that then a police not doing their job and actually becoming criminals versus agents of the government problem in Mexico specifically? I think it's a bad example because it's vulnerable to a counterexample like Syria, where the police, they violate people's rules all the time, and they are corrupt all over the place. But the society stays intact because they're corrupt and they're evil in the name of the government. So, where do you draw the distinction? I mean, what's the government's place here in making sure corruption, that this exclusionary rule tries to carve out? What's its position there?
Well, I think the government should abide by the laws and they should hold themselves to a higher standard. I mean, and enforce the laws that are imposed on them. I mean, that's how I think the government should be. I mean, in our system of governments, I mean, not only are the American people under the rule of law, but the government's under the rules of law as well.
So what practical is lost if we become a Syria or a North Korea?
If we turn into a country like Syria and North Korea?
If our police at least act like the Syrian or North Korean secret police.
Like, what would the consequences of that be?
What are you trying to protect? I'm being a little belligerent here, but yes.
With the exclusion rule, what are we trying to protect? We're trying to protect the American people from the government.
You're trying to protect us from becoming Syria or North Korea.
Right.
Yeah.
Any more questions or clarifications? Or?
So is the United States the only country that has the exclusionary rule?
Well, it's the only country that has a rule in the books that's called the exclusionary rule, but other countries do exclude evidence from trials. Like,
They do it on a more case-by-case basis?
yeah, it's up to the judge. It's up to his discretion. Like in Germany, it's up to his discretion. And the British government, it's up to their discretion as well.
So those countries seem to be doing okay. Most countries seem to be doing okay without it. Where most European countries don't have it. They
Right,
seem
but
to be doing all right.
there was a trend for them to start broadening their exclusionary powers. I think like even in 2003 in France, there was an article I read that they were even trying to broaden their exclusionary powers, and they weren't relying on the deterrence effects that we were relying on here. It was more of a judicial integrity argument in those countries.
So, I mean, I guess, just because I pointed out, you have the consequentialist argument, and maybe it looks fine as a consequentialist argument. But, you know, when we were talking about the sacredness stuff, it seems you could also argue on that basis and say, well, I don't care about the consequences of the sacred.
Right.
So just curious, as a strategic point, why the consequentialist argument when it sounds like you would be happy to defend a non-consequentialist argument?
Well, I think that. So why ultimately did I pick the consequentialist
Yeah, it's
argument?
a strategic question.
I mean, that's just essentially that's what I picked. I thought that showing what good the exclusionary rule produces may be more persuasive than other effects. I mean, I had looked at defending it through like Rawls's theory of justice initially as well, but I thought in the end the consequentialist I thought would be more persuasive than the other.
So if I may ask then, as to the origins, if other nations in Europe or wherever that we consider civilized are broadening exclusionary powers, not out of fear of the government itself, because it's the governments that are doing this, but perhaps a public confidence argument in the judicial system, it seems that that is completely different from what you claim is the reason for the exclusionary rules backing in our Constitution, which is a fear of government.
Well,
And an inherently conservative impulse that maybe isn't the case in Europe.
Right.
So are the two cases even comparable?
Well, I think that initially when the Weeks Court adopted the exclusionary rule in 1914, they did have the judicial integrity. That was one of their main underlying assumptions, that it would preserve the courts and it would deter police misconduct. And as the exclusionary rules evolved in the United States, that judicial integrity argument got dropped. It was dropped in either in Mapp versus Ohio in 61 or Wolf v. Colorado. But they essentially, when it first was founded, it was founded under that rationale.
You also have to understand some of these things go in phases as far as the U.S. Supreme Court is concerned, because first you have the Warren Court, which was very liberal on the rights of the accused. And you went to the Berger Court, the Rehnquist Court, and now the Roberts Court. You've had to involve, moving more towards, the rights of law enforcement as opposed to the rights of individuals. And someday, the pendulum could swing back the other way.
Yeah, exactly. Yeah, the Warren Court was the one who expanded the exclusionary rule, and I do believe they even adopted Miranda. And then it was the Berger Court that preceded that, and the Rehnquist Court, and now the Roberts Court that essentially have really cinched in on narrowing how to interpret the Fourth Amendment, and also narrowing when the exclusionary rule applies. In recent years, I don't know, more cases have been cited on favor of the law enforcement than have been the individuals. So that's a good point.
So then what good is that rule and its guarantees and its effectiveness if judicial fiat can just write it off? You appealed at the beginning to our personal rights and our responsibility of claiming them for ourselves if we want to keep them. So is there perhaps a better way of working this rule if we want to keep it somewhat secure than via, I guess we have so far, judicial fiat?
Yeah, I think if the courts would have followed the stare decisis principle and from like when the court adopted it in weeks and they carried it through, but I mean that seems to be more of a consistent view than this court ruling this way and this court ruling this way. I mean, there was a lot of gray on essentially when it applies and when it doesn't apply based off the Supreme Court's ruling. And one of the hard things about this paper was trying to figure out, essentially in this case, like, is it going to apply in this case or is it going to apply in this case? And really the only way to find out is to take it to the Supreme Court. So.
we're down to our last couple minutes. If you have a question, just all but formulated, just spit it out. Because otherwise we have to end.
You used the term, I'm sorry, somebody else?
Oh, you can go ahead if you want.
You use the term of a person who is involved in this being obviously guilty. How do you determine that?
Well,
How can a person be obviously guilty?
well, in the case of Nix v. Williams, he admitted to killing the little girl, and then he walked him to the body. So, I mean, to me, that
But if you didn't have that conviction, what standard would you use?
what standards do the courts use? They use the beyond a reasonable doubt standard, which is about, it's not absolute certainty because then very few people would go to jail, but it's under that into like the 90 percentile range. That's how our courts.
Just asking because I've never heard that phrase before.
Oh
Sorry.
yeah, that's all right. Do you have a question, sir?
Yes, where it's more of a conservative trend too with the, like with the later Supreme Courts, like the Berger. It's like with automobile searches at one time. I mean, there's been a trend, more again for law enforcement rights and as far as searching automobiles, because a lot of times search warrants aren't even required. A lot of times, I think ones were.
Yeah, I mean, a lot of gray gets into the warrantless search areas, and the limitations on the exclusionary rule have been broadened. Like the good faith exception has been broadened. I mean, almost to degrade the rights that we have in the Constitution in matters of that. So, yeah, I mean, our rights have. I mean, since the Map v. Ohio decision, I mean, our rights that in the 4th, 5th, and 6th Amendments have been dwindling. I mean, as time goes.
You use consequentialism, and I don't know if you cover this in your paper, but what would you say to someone who said that the greater good was produced by violating the exclusionary rule? That by getting killers off the streets, that's a greater good than protecting people's privacy?
Yeah, but I think that the exclusionary rule, I think one of the misconceptions about it is the major offenses against it are like firearms violations and like narcotics violations. And the reason for that is because there's only that evidence in those types of cases. So, I mean, we're really not letting murderers off the street. And I mean, and the courts have other remedies as well, I mean, to ensure that justice is served, like in a case where, like, let's say there's a cop conducted a search and he found the gun without the search warrant. And I mean, essentially that was the only type of evidence he had. I mean, they could essentially assign that police officer to a duty and bring in another police officer to see if he could find that legal means, and that would be admitted. So I think, I mean, is the exclusionary rule letting like murderers off? I don't think so.
Kind of an extreme example, I guess.
I think that is all the time we have for now, although you could talk about this for a little bit longer while we eat cookies and drink punch.
Awesome.
So we'll gather again in about 5 minutes.